Hello YouTubers, this is Han, and this here in the second of my videos about the American criminal justice system, I would like to give an overview of how a case starts to how it ends, without talking about appeals. So a case will start on the street. The police will investigate a report of a crime. Um, this report, either it's something that the police sees, for example, an officer could be doing patrol and sees somebody driving all across the road in an erratic manner, pull this person over, smell the alcohol, do the roadsides, and then write that person a ticket for DUI. That is the charge. Or it can involve a more extensive investigation. A detective at a police agency might talk to witnesses, might talk to informants, might do undercover work, might collect evidence, send it for testing, and compile a case before sending it to the district attorney's office for charging. So a case starts out on the street with a police agency. We have three main types of police agencies. There are the police, which are municipal law enforcement. So if you live in a municipality, or maybe some towns, but it's a city, right? There will be a police chief appointed by the mayor, or if it's a city that doesn't have a mayor, if it has like a city council, by the town council. You also, in Colorado, live in a county, unless you live in Denver or Broomfield, where it is the city and county of Denver or the city and county of Broomfield. But they too have sheriff's deputies. So the sheriff handles investigating crime in the county that is not also part of a city. They also run the jail. So if it's an urban jurisdiction, the sheriff probably just runs the jail. However, if you're in a more rural jurisdiction, then you might have little towns, but most of the area of the county is unincorporated. And so law enforcement there is run by the sheriff's department. For example, I'm living here in the mountains, and my residence is not actually within the boundaries of a municipality. So if something happens here outside or inside my place, then it would be the sheriff's department that investigates. The difference between sheriffs and police officers are the sheriff's deputies are accountable to an elected sheriff, who then is in turn accountable to the people of his jurisdiction. We also have state police agencies. This is primarily the Colorado State Patrol. Colorado State Patrol, they have jurisdiction over the highways of Colorado, so the interstate highways, the U.S. highways, the state highways, not county roads, but they have jurisdiction over the state highways, and they also do security for the governor. So these guys all do street level police work or detective police work, and they will either charge it if it's a misdemeanor, or they will send it to a district attorney's office for charging. There are 22 elected district attorneys in Colorado because we have 22 judicial districts. We have more than 22 counties, so each judicial district contains one or more counties. I think the ones that contain only one county are the city and county of Denver, the city of Boulder County, Weld County, Pueblo County, and Mesa County. Mesa County is Grand Junction. Everything else are more than one counties. So for example, the 18th Judicial District includes 4 counties. This is actually the most populous district in Colorado. It includes Arapahoe, Douglas, Lincoln, and Elbert counties. And the city of Aurora is mostly in Arapahoe County, although some of it bleeds into Adams County, and some of it bleeds into Douglas County. But so what you have in the 18th is you have 2 urban-suburban counties very close to Denver, and then you have 2 counties that are a bit more rural, heading out towards the east. So that is how our state is set up as far as state courts go, and for each of these judicial districts there is an elected district attorney. So when the district attorney's office in the jurisdiction gets the case, the district attorney's office will make a charging decision. If it's the ticket, the DA can change the charges on the ticket. The DA is not bound by what the police do, so the DA can add charges, can amend charges, can just dismiss the ticket outright if the DA thinks that it's BS. So the DA has a lot of power to bring charges. If the DA charges the case himself, the DA will generally first start by charging it in county court, regardless of whether or not the case is a felony or a misdemeanor. So, county court is the lowest level of state courts. They handle a lot of the type of cases that normal citizens would see. Right? They do small claims. They do temporary protection orders, and they do misdemeanor crimes. The distinction between a misdemeanor and a felony nowadays is prison. For a misdemeanor, the defendant cannot be sentenced to prison. For a felony, the defendant can. And prison is the State Department of Corrections. So you're talking about longer sentences in the more serious facilities. The distinction, a felony actually used to mean death, right? That's what made it a felony. The possibility of death and attainder. In the last 100, 200 years, the death penalty has been scaled back, right? Nobody's getting executed for theft anymore. And so, and we don't even have attainder in America. Attainder was this penalty that we saw in England, whereby if a nobleman committed a felony, not only would he lose his life, but he and his family would lose titles and land, so there would be corruption of blood, there would be forfeiture of all lands and personal property to the crown. It ruined your family. And that's what attainder was. In the US Constitution, we have prohibited bills of attainder. So, I mean, we have no titles of nobility, but you can't punish somebody's family for what he did. And so we don't have attainder in the US, but we still have death penalty, but death penalty is not for ordinary felonies. It's only for the most serious felonies nowadays. So what a felony means today is it's called a felony and you could go to state prison, which is different from county jail. County jail is, in theory, a place you are held prior to trial. Although you can be punished by incarceration in the county jail for committing a misdemeanor, the origin of jail is actually a holding facility prior to trial. In America, we have the presumption of liberty. So people are on bond generally before going to trial, right? We trust you to come back and handle your case the appropriate way. If you give us reason to not trust you, right, we think you're going to run and try to flee justice that way, or we think that you are going to be a danger to the community by committing more crimes, particularly intimidating or retaliating against witnesses, then you can be held prior to trial in jail. So that's the difference here. County court handles misdemeanors, and district court handles felonies after they're bound over from county to district court. So a county court case, a misdemeanor case, will start off with the charging document. You will be summoned, usually, into court to answer charges. At that time, the judge will give you an advisement of what your rights are, an advisement on what the charges are, and the district attorney's office will make the defendant an offer most of the time. The district attorney has no obligation to do so, but most cases get resolved by plea bargain. And so the DA will make an offer, and if the defendant wants to take it, the defendant can take the offer and will plead guilty pursuant to that plea agreement, or the defendant can exercise his right to go to trial and will set the case for trial. The court hearing where that decision is made is called the arraignment. And while a defendant could go to immediate arraignment on the first appearance, usually there's a second court hearing for the defendant to consider the DA's offer or to decide whether or not to get a lawyer before making that guilty, not guilty decision. If at arraignment the defendant pleads guilty In county court, the defendant might be sentenced immediately. For example, if it's a disorderly complaint, right, bar fight that gets charged as a disorderly, and the judge is inclined just to fine the person or just put the person on a period of probation with community service, there might not be any sort of investigation into the defendant's background, and this person will be sentenced immediately. Or there might be a pre-sentence investigation done, and the defendant will come back for a different sentencing date. If the defendant pleads not guilty, what will happen is that the case will be set for usually a jury trial, and this is a jury of 6 in county court. And there will also be a motions hearing date. The motions hearing is a date prior to trial for both the defense and the prosecution to raise any issues that need to be resolved by the judge outside the presence of jury. Most of the time, these issues come from the defense, because the defense will hold the people to their burden and contest the legality of the police contact. The defendant might want to say, or the defense attorney usually will want to say, that the stop of the defendant was illegal, or the evidence collection was unconstitutional. And this is where they require the prosecutor to bring in the witnesses to establish the constitutionality of the police contact. And this obviously is taken outside the presence of the jury. Once it gets to the jury, these have to be resolved, right? Either the police acted constitutionally and the jury gets to see all that evidence, or they did not, and that evidence is suppressed, and the prosecution has to try the case without that evidence. And if they can't, then maybe they just dismiss the case and it never goes to trial. So the case gets dismissed prior to trial. But that's what the motions hearing is. It's so that legal issues can be resolved outside the presence of the jury. Thereafter, there's a trial to the jury. The jury must be unanimous, whether it's acquittal or conviction. And then if the jury convicts, the defendant is facing sentencing either immediately or after a pre-sentence investigation report is generated. Or if the defendant is acquitted, then he just goes free. A felony case is actually very similar to that. It will usually start off in county court with the DA filing a complaint listing the charges. Sometimes these charges are eligible for a preliminary hearing, and I will talk about that in a later video. But a preliminary hearing is a hearing in front of the judge where the DA proceeds by hearsay, largely, to establish probable cause to believe that a crime was committed and the defendant was the one who committed the crime. Probable cause is a very low standard. It is below the standard of proof in a civil case. In a civil case where people are suing each other, the burden of proof is usually preponderance of the evidence, right? More likely than not. Probable cause is a standard where a reasonable person would have a reasonable belief that the crime was committed and the defendant did it. And so if the prosecution can establish probable cause, the court will then bind over the charges to district court, and the prosecution will file what's called an information in district court. It's actually usually the same document as the complaint for the case to proceed in district court. If the county court does not find probable cause, then those charges will be dismissed, and the DA either has misdemeanors or has felonies that were not eligible for preliminary hearing to go to trial. So then there's also an arraignment in district court, and then there will be a motions hearing, and there will be a trial. In district court, you are talking about juries of 12. For particularly serious cases or cases that have a lot of emotional resonance, like rape cases or murder cases, there will be one or more alternates. Actually, most district court cases will have an alternate juror because 12 citizens, these cases usually last more than a day. Somebody might get sick, somebody might get delayed, and so there's an alternate juror so that the case does not mistry and you have to start it all over again. For a murder case, you will probably have 2 alternates. For a serious rape case, you will probably have 2 alternates. For that death penalty case, I mean, I think they had something like 10 or 12 alternates. So that um, that's how jury trial works. So that is the overview of how a case starts to where it ends. In my next video, I'm going to talk a bit about what an indictment is and what a grand jury does on the state level. Thanks for watching, and if you have any questions or comments, put them in the comments section below, and I'll see you next time. Thank you. Bye.